In 1996, Senator Ron Wyden co-authored with Republican Senator at the time, Chris Cox, Section 230 of the Communications Decency Act. He can only join us for a few minutes, so we are going to go to him at the start, and we're going to chat for a few minutes, and then after he needs to leave to take on his rest of his important business, I will then introduce the rest of the panel. So welcome, Senator Wyden. We're so glad you could be with us today.
Vivian, thank you so much. And as usual, Aspen is stepping up to address important issues because I can't think of a time when it's been more important to have free speech online. And so I really commend all of you. As you touched on in your comments, I just heard a couple of them, Vivian, because it came in from a vote. Donald Trump is waging an all-out war on the press, and pretty much anybody who seeks to hold him accountable or actually disagrees with his lies, including Twitter. Over the past week, there's been an outpouring across the country for a fairer justice system in particular that ends the violence against Black Americans. And 230 is really important to both of those stories. Now, Chris Cox and I were congressmen back in the 90s, and we wrote the Communications Decency Act to give up and coming small tech companies, in particular, small ones, innovators, a sword and a shield. And our goal was to foster speech online and innovation online. So what 230 says is that users, not the website that hosts the content, are the ones responsible for what they post, whether it's on Facebook or in the comments section of a news article. That's what we, in effect, are calling the shield. But we also gave the companies a sword so they could take down offensive content, lies and slime, the stuff that may be protected, as we know, by the Constitution, by the First Amendment, but that most people certainly do not want to experience online. And so they're free to take down, for example, content of white supremacists or flag tweets that glorify violence without being fearful of being sued for bias or even have to shut their site down by a radical president. 230 does not give a president, the executive branch, leeway to act. So I've got a lot of reservations about what big tech companies are doing today with respect to violating Americans' privacy. I actually have the toughest bill on offer with respect to the big tech companies and violating privacy. We say, for example, if the big tech companies lie to the government and their consumers, that not only would they face financial penalties, but their top executives could face criminal sanction. So I've tried to send the strongest possible message about this wrongful conduct by the big tech companies with respect to violating privacy. But I also think, apropos of 230, that the big tech companies are not doing enough to take down the slime online. Social media has been a huge megaphone for people without access to money, who have trouble accessing conventional media, or who want to challenge those in power. But I think it's also important to recognize that the big players, the big ones with deep pockets, haven't done enough. And I want to make sure that we have the opportunity for the little guy, the innovator, who could be crushed by these big companies, to have a chance to get ahead. And so without Section 230, in other words, Vivian, you just throw Section 230 in the trash can, sites would have strong incentives to go one of two ways. Either sharply limit what users can post so as to avoid being sued, or to stop moderating entirely, which of course is pretty much 8chan. I think we would be worse off under either scenario. I mean, just look at Black Lives Matter and the protests against police violence over the past week. The reason Americans learned about the unjust murder of George Floyd was a cell phone video posted to Facebook. So many of these cases of unjust use of force against Black Americans have come to light in just that way as a result of a video posted to social media. So in a world without 230, I cannot imagine that Facebook or Twitter would allow possibly defamatory posts about police violence, and these horrible injustices would never get the public attention they deserve. And most importantly, accountability would be even less likely. Now, what Donald Trump really would like to have is the other scenario, for platforms to be, quote, neutral. You hear him say this morning, noon, and night. The platforms are neutral. This law that these Congress people thought up is supposed to have neutrality. I think everybody understands there's no kidding around here. Trump doesn't care about Section 230 or any other complicated law. And by the way, the law makes it clear that there's no statement about neutrality. What Donald Trump wants to do is bully Twitter and Facebook into letting him post his lies without any challenge. And so without 230, I think that a lot of sites would choose not to moderate at all and thus avoid responsibility for anything that their users actually post. So it goes without saying that there would be more false and more dangerous content out there, and it would be revenge porn, the white supremacy. The internet would become the cesspool that anti-230 activists are saying that they're most concerned about. I've seen some articles saying Donald Trump would be in big, big trouble without 230. I would just have to say respectfully, I disagree. He's the president of the United States, the most powerful person. He calls a press conference and news networks carry it live. Reporters, repeat his statements. An army of surrogates repeat his talking points on practically every possible medium. If Twitter banned Donald Trump tomorrow, he would not have any trouble spreading his message to every corner of the world. But without 230, the people that I was concerned about from the very beginning, the little guy, the person who had a dream, the political movement that didn't have money and clout, movements like Me Too and Black Lives Matter, without 230, they would find it a lot harder to challenge the big corporations and powerful institutions. Without 230, it's a certainty that not a single Me Too post would have been allowed on moderated sites. So that's why I'm strongly opposing, one, the president's executive order, legislation like the Earn It Act, which is schemed up by Bill Barr to basically set up a speech police to control speech online and then to gut strong encryption. And I can tell you, Americans don't want to be at the mercy of speech police online or anywhere else. And 230 gives sites and speakers and readers choices and ensures that the choices are going to survive the hostility of people like Donald Trump, who have immense amounts of power. And we feel very strongly about this. That, I'll just close with this. I mean, I've been the first advocate of national vote by mail. I introduced that legislation in 2002. Back then, it was just kind of an academic set. I bet there were conferences at Aspen, about it. What Donald Trump was doing was lying about, vote by mail. He kept saying, oh, it's going to lead to systematic voter fraud. And he wanted to force Twitter to post his lies. And so that's why these issues are so important. And I look forward to hearing about the results of your program. And under normal circumstances, I'd set in for, every bit of it. We got another vote in a couple minutes, but
Senator, if you have just 1 minute, I'd love to ask you just a very quick follow-up question.
Yeah, sure.
Presumptive Democratic presidential nominee Joe Biden, Vice President Biden, has been on the record saying he would like to dismantle Section 230. What's your response?
Well, I'm going to let the vice president speak for himself. I mean, this is, of course, an issue that I think people are going to look at with fresh eyes based on the events of the last few days and weeks. And what I intend, because I'm a supporter of the vice president, is I intend to make the case, because a variety of important Democrats, people that I like, think that this is some kind of gift to, big tech. Big tech is a group that was willing to sell out the little guy on the SESTA-FOSTA bill on sex trafficking. Big tech doesn't want the little guy to have a chance to be heard. And I think that given the events of the last few weeks, how Donald Trump has been willing to bully Twitter into trying to get his lies printed, and the implications for voices that are otherwise not going to get heard, like Me Too, my hope is that I'll have a chance to tell the new Democratic senators, because we're counting on having some of them, and a new president, what this really means, especially looking at the prism of the last few weeks.
Okay. Thank you. Thank you, Senator. I know you're very busy. You need to go, but we really appreciate you joining us.
Thanks for having me.
Okay. Thank you.
Bye.
But stick with us, everybody. We're going to continue from here. Obviously, there was a lot to unpack there. The sword and the shield, and a lot of reference to the specifics of the events of the last week. We are going to be joined momentarily by Kate Klonick. She is with St. John's Law School. There she is. She is an expert on law and technology, lately with a focus on private internet platforms and how they govern online speech. She's going to just walk us briefly through the events of the last week, and then give us a little bit of a primer. And then we are going to be joined by two others who you will see after Kate is done. Tim Wu of Columbia Law School, who's known for coining the term net neutrality almost 20 years ago, and a champion of equal access to the internet. He is a best-selling author, of course, of several books on the issues of free speech and information warfare. We will also be joined by Marianne Franks with the University of Miami School of Law, where she teaches First Amendment, law and technology, and criminal law and procedure, and is the head of the Cyber Civil Rights Initiative, a nonprofit organization dedicated to combating online discrimination and abuse. Just a little bit of housekeeping before Kate presents. After Kate presents, we're going to be, I'm going to be asked questions of our panelists for a few minutes, and after that, we are going to hear questions from you. At the bottom of the screen, you see the Q&A button. Please, at any time, starting now, anytime, please click on that Q&A link and write your question. We'd ask you please to include your name and your affiliation if you are comfortable doing so. That really helps us provide, that really helps with sort of helpful context. So again, anytime, just click on that Q&A. Okay, Kate, thank you. We will now turn it over to you to tell us exactly what has gone on in the last week, and then we'll come back with everybody.
Thank you so much, Vivian, and thanks for having me. This is a tremendous group. I think that's like a wonderful kind of set of people with very slightly different but reasonable views on Section 230. And I kind of have prepared a very brief PowerPoint to kind of walk us through some of the craziness of, it's hard to believe that it's only been a week, but it's only been a week. And let's see. There we go. So 1 week ago, on Tuesday, May 26th, my morning started off with this this headline, a column by Kara Swisher that was calling out Twitter for basically keeping up a number of very conspiracy theory, provably false tweets that the president had been saying about the death of an intern that had worked for Joe Scarborough, who's one of the kind of enemies of, I guess, of, just so to speak, of the president. And momentarily, I thought this was going to kind of be the story of the day, but momentarily, there was yet another story on the same day. A number of tweets that Donald Trump posted online about mail-in ballots were labeled by Twitter. You can see here, get the facts about mail-in ballots. I'm just kind of pointing out what this looked like because it did change a few days later how they were kind of doing this. So this was a new, as Vivian said before, this was a new moment for Twitter, labeling things, so to speak, by giving people the option of more information about the given thing. You'll note that they did not say that the tweets were false or that the tweets were true. They just said, get the facts about mail-in ballots. And so this was shortly thereafter, I think later that day, or the next day, Wednesday, May 27th, the president's press secretary stated to the press that leaked the idea that there was an executive order in the works about social media. And now that was not a new thing. There had been about a year before a very similar threat of having an executive order when the president was unhappy with something that social media was doing. And so people didn't really know what to make of it. And by the end of the day on Wednesday, a draft of that, by that night, I think on Wednesday, a draft of the executive order preventing online censorship was sent around. It was about 6 pages long, and it stated exactly kind of what they were going to do to Section 230, what administrative agencies they were going to involve in reaching out to on this particular executive order. On Thursday, May 28th, so still just 2 days, and I'm not even mentioning the riots and everything else that was happening. On Thursday, May 28th, there was a question about whether or not this executive order was actually going to be signed, and in fact, it was. The president, I think, signed the executive order at 4:45 on Thursday, and he made a statement that basically the order itself basically said that blame Twitter and other sites for basically putting warning labels on certain tweets in a manner that clearly reflects political bias. And as has been reported, Twitter seems never to have placed such a label on another politician's tweet. And then also stated such things as it relates to the Section 230 conversation that we're having today, that basically reference the fact that tech companies have grown into these huge titans of national discourse, and then attempts to basically put a new kind of pressure on tech companies at the risk in order to basically prove that they have not engaging in editorial conduct or to put these types of fact-checking labels on things. Else they will be lose their limited liability shield of Section 230. So this kind of, we can get into this later, but all of this was basically, I think, in the media was by experts who were talking about it on Thursday, was basically saying that there was not a whole lot of legal weight to the president's executive order, not a whole lot that he could do. In stating this, he puts out there that he has offered a new interpretation of Section 230, but that flies in the face of 25 years of judicial interpretation of the federal legislation. And so it's not clear that he has the power. It's not clear that he has the power to do this, probably does not have the power to do this. And so it's was this toothless executive order that came out. And the real question I think that most people were asking was, okay, so he's kind of thrown the gauntlet down to a certain extent, even though this is not maybe the fact that maybe these tech companies are just not going to want to mess with this kind of this threat no matter what, at the risk of losing Section 230. Maybe they'll back down, maybe they won't. They won't be as rigorous in what they're doing with moderating content and with fact checking as people are really calling on them to do because of the president's threat. And in fact, that was the exact opposite of what we saw happen on Friday. The president tweeted a number of tweets about the riots in Minneapolis, specifically around George Floyd. And then Twitter put up an interstitial, more than just a label. An interstitial is like this post over that you have to basically click through in order to look at what the underlying tweet was. If you do click through, the interstitial remains as a label at the top of the page, and then you can see specifically what the president said. In particular, this was the very controversial, when the looting starts, the shooting starts, which was the precise language that was found to be basically a call for violence and therefore not allowed under Twitter's content moderation policies. So, this is, if you click through to the more information, this is what Twitter gives you, and it states defining what is in the public interest. There is tons of literature around this. It is a very thorny issue, both in First Amendment law and in private platform governance, almost more so in private platform governance than in First Amendment law, I would almost say. And it's a very hard question, and depends on different platforms, as we know, draw this line at different places. Twitter is deciding to draw it like however they draw it, but Facebook, as we know, because of Zuckerberg's statements, has decided to draw it at a different point. And so that brings us to Saturday, May 30th, 2020, in which, as far as I know, I hope nothing, besides Twitter continuing to roll on and the world continuing to spin, the shuttle went up into air, and I, for one, wish that I was on it. And so it has been an absolutely exhausting couple of days, and we have so much to discuss, and I'm looking forward to doing that today. Thank you so much.
Thank you so much, Kate. That was really helpful. We're going to bring our other panelists in now. Welcome, Tim. Welcome, Marianne. There's just so much to unpack here, and I'm thrilled to see how many questions are coming in already, really thoughtful questions. Again, just a reminder, click on the Q&A button to enter your question. Please add your name and your affiliation. If you feel comfortable doing so, it's really, really helpful context. Kate, there have been, there have been calls to dismantle Section 230. Obviously, Senator Wyden, who co-drafted the bill, is a strong supporter of it. But as I mentioned, the Democratic nominee Biden has called for it to be dismantled. What needs to happen, in your view, for Section 230 to be more effective?
I mean, I agree a lot with much of what Senator Wyden said today. I think that in particular, the idea of just simply dismantling Section 230 is not really the right approach for specifically the over censorship threats and the under censorship threats that he describes. I don't think that it makes a lot of, I think that one of the things that we do forget about a lot is how often the internet has empowered people and empowered people's voices, while simultaneously, and Marianne knows more about this than most, and she's covered it extensively in her work, but while the internet rains down harms on women and minorities in ways that it doesn't, it also does bring to light massive systemic injustices that are there. Whether those trade-offs are in the right place is, I think, something to be discussed, and whether we have enough protections without kind of quashing the ability for people to project their voice out there is really like, I don't think Section 230 is doing a perfect job or a very good job of it right now. But at the same time, I don't think that throwing out the baby with the bathwater, so to speak, is really the best way forward. I think that we're kind of in need of like a surgical level change to some of how we interpret Section 230.
Okay, we'll get into that more in a minute. Tim, you mentioned earlier that you have a piece that's about to be published. I don't know if it's been published yet in the New York Times about all of these issues. Do you want to preview what it is, your point of view?
Hi, everybody, and thanks also to everyone who's spoken. I like that, the idea of being up on that rocket. It does sound kind of appealing. So I think that there are really interesting and hard questions around Section 230 and then content moderation, which is actually separate. Sometimes we kind of mix these up, but those are actually
Explain.
separate questions. Is there, sorry, but
Go
I
ahead and
want to
explain that just briefly. So
yeah. But I want to focus on the executive order itself. That's what I've written about in the Times, which is coming out at 3 o'clock. I think it's very important, no matter what you think of the debates over content moderation or what you think about Section 230, that the executive order as the device to even consider this needs to be resisted strongly. And in fact, I think it's very, very important that that effort, which represents an effort by the president, the office of the president, unilaterally set the content moderation policies for every website, needs to be rejected by everyone who believes in free speech. And not only do you have to reject it, I think it's important that we pretend the executive order does not exist, because if you even give it any credence, you are allowing the president an unconstitutional authority to harass, to dictate what he's doing. And I say that because it's very obvious I mean, it's Twitter's named 6 times in the order. Individual employees are discussed. It is obviously unconstitutional retaliation. And I think it's, in the piece, I call upon the FTC and the FCC, who are the agencies who are supposed to enforce it, to ignore the order. It is also overstating the role of the president in terms of legislation. So I just think that's very important. Whatever that other debate is, we need to not allow, and I want to say, this is the last thing I want to say this, we have to understand content moderation policies. I think they are the equivalent of the editorial independence of the press. So, it's a very hard question what they should do, but having the president try to dictate it is not unlike having the president dictate, the editorial policies of the New York Times, Wall Street Journal, Fox News, whatever. And so that is where social media needs to take its stand with the First Amendment behind it.
So just a couple of clarifying questions, yeah. Tim. So your upcoming op-ed in the New York Times is calling for the FTC and the FCC to ignore the order. But if I understand correctly, and tell me if I've got this wrong, the signal from the executive branch is that they are going to be sending a set of recommendations for consideration to the FCC and the FTC. Are they not legally bound to address those?
No, they're not. They're both independent agencies. Neither of the heads of the agencies can be fired under the Constitution by the president. And if you notice, it's worded shall consider or shall consider. And both of those officials, the chairman of the FCC and the FTC, I worked at the FTC myself, have been sworn duties to uphold the Constitution. So I think this is kind of a moment where the independent agencies have a duty not to take action on an unconstitutional order. So there's a little bit of ad law mixed in here, constitutional, but I think it's very important that we not allow the precedent to be set, that the president can unconstitutionally threaten people and get something out of it. Because after that threat happens, it's like the cop who arrests people. Eventually a court might let you go, but if you have a cop who feels they're empowered to arrest people and get what they want that way, it sets a very dangerous precedent for just violations of the First Amendment whenever you'd like.
Marianne, let's stipulate, as I think we have clearly, that the platforms have the right under Section 230 to do as they please as private actors. But what could and should the tech industry, the platforms, be doing with that right to mitigate harms?
Well, I just want to say first that to clarify, they have the right to do what they want, not because of Section 230, but because of the First Amendment.
Right.
Part of the really important, one of the most important messages here about the First Amendment that is getting lost is that private actors, in exercising their free speech rights, are allowed to say, I don't want to carry this content. I don't want to be a megaphone for really terrible speech. And so it's not Section 230 that protects them in that, it's the First Amendment. So I think that's really important to just to add another Orwellian layer to this, that what Trump is attacking is Twitter's own exercise of its freedom of speech. But I do think it's pretty broad consensus, at least maybe among these panelists, that the order is incoherent and it is impotent largely. And I think that we can agree on that and then ask ourselves, now what? Why does it exist? What impact will it have? What are the real dangers of it, in addition to the ones that Kate and Tim have already mentioned? And I'd say some of the other dangers are indeed legitimizing the very real and important conversation that needs to be had about the way the tech industry operates and has been operating because of Section 230. What's extraordinary, and I wrote about this in The Atlantic a few days ago, is that the very thing that Trump is accusing Twitter of, the idea that, oh, you have all this power just to shut people down or to say what you want or engage in bias and there are no consequences, that's as apt of a description of the tech industry under Section 230 as I've heard. The problem is that both Twitter and Trump have that kind of immunity, and they shouldn't. And so when we're trying to figure out where to go from here or how to think about these very difficult issues, I think Tim is right to not get sidetracked by this ridiculous order, but to notice what the tactics are here. Trump presents himself as a victim. This is something I've called in my book victim claiming, and Twitter does the same thing. The tech industry does the same thing. The sponsors of Section 230 do the same thing and suggest that the tech industry, social media, is somehow should be credited with the kinds of issues that have come to light and some that have set off major world events. It's an extraordinary selective sort of taking of responsibility, right? So Facebook and Twitter say, look, we're the reason why these videos are getting out about police brutality, but we have no responsibility for the police brutality that is then unleashed in response to protests over this. Or we take no responsibility for the fact that the president himself will use our platforms to incite violence against his own people. Interstitials are interesting and great, but that doesn't actually say anything or do anything about the fact that Twitter helped create Trump. We have Trump in part because of Twitter and because of Facebook. And that's underscored by the fact that Mark Zuckerberg and Donald Trump were having a conversation just a few days ago that apparently Trump was very happy about, no doubt. So I think that's one of the things we need to look at, not get trapped in this idea of who's the real threat to free speech. Is it Trump or is it social media? They're both threats to free speech because they are allowing for people to engage in incredibly injurious behavior, sometimes behavior that can never be taken back, that cost people their lives, that cause people to poison themselves, that cause people to lose their homes and have to change their names. That is true of Section 230 and what it has wrought, as much as it's true of what Trump is trying to do. And so we have to acknowledge that, and we have to start having that conversation about the real problem with anyone, any powerful entity, being able to engage in behavior that profits them personally and pushes all of the negative consequences onto vulnerable populations. If any of us care about freedom of speech, if any of us care about the experiences of vulnerable populations, we have to care about how we got here to begin with. And if social media companies are attempting to try to say that they're not part of the reason where we got here in this polluted information environment, full of disinformation and misinformation, full of incitement, full of threats, full of violence, then that's not an honest conversation at all. We have to be thinking about how Facebook is part of the reason why we're here, thinking about the fact that Trump performs for Twitter, performs for Facebook. It's not just, no matter who says it, shining a light on behavior. It creates behavior, it generates behavior, and it gives cover to all sorts of forms of behavior that are not only toxic to free speech, but toxic to democracy itself.
Yeah, you bring up, Marianne, you've mentioned the conversation that Mark Zuckerberg had with the president last Friday. He has taken, and Kate, I'm directing this question to you, he's taken a very different posture than Twitter has. Twitter has sort of dipped its toe into this kind of moderation. It hasn't fully jumped into the pond yet entirely. But Facebook still has taken a very different posture. Zuckerberg specifically differentiated himself from Twitter's actions by saying he doesn't want to be, quote, an arbiter of truth. How do you see Facebook's decision? I should note for everybody listening that Kate is really an expert on a lot of what Facebook's activities have been, including the establishment of their new Facebook Oversight Board, who have suddenly just been formed and now under a lot of pressure.
Yeah, so there's a couple of things, and I think this would maybe a good time to bring up the Facebook protest walk, the virtual walkout that happened. I think that that's kind of an interesting idea that has of how that has rolled out in response to this. So I think that a lot of what Marianne said is totally correct, that you see power, Section 230 does allow power to like recapitulate from the real world online. And the same things that that got us here are the same things that have are the basis of all inequity that we had even before the internet. We just see it in maybe starker relief to a certain extent. But as to Zuckerberg's conversation with Trump, I think that basically Facebook right now is trying to differentiate itself from Twitter in the market. And that's something that you've seen both of these platforms do in the last couple of months and just in general. So when Facebook was refusing to police political ads back in October and November, you saw Jack Dorsey right before the earnings report at Facebook announce publicly that he was going to take down all political ads on Twitter itself. Some of these plays are just like complete they're complete like boys with toys kind of things in my belief, like basically. And what I mean by that is there's a $300 million business per quarter at Facebook on political ads, and it's 3 million on Twitter for like just in terms of different. I mean, I fact check those numbers for me, but it's about that differential. And it was very low cost and very high profile for Dorsey to come out and say that against Zuckerberg. And I think that you're having the same thing happen here, and Zuckerberg perhaps trying to pander to the right and social conservatives. I will also say that like this is kind of the idea of like creating a market for rule sets that that a lot of people in early internet scholarship days talked about happening on various platforms. But getting to kind of something interesting, which is what it is about employees walking out virtually or otherwise. We saw real life walkouts in Google a number of years ago. We've seen protests at Twitter and at Facebook throughout the last couple of years. And I want to just kind of point out this interesting phenomenon that's been called thrashing, when employees protest collectively. It's like people used to protest for better labor conditions and better pay if they were employees. They didn't protest to change the public policies of the companies they worked for. And so what has changed there? And I think that it really kind of gets to the fact that there is this huge delta of power between power difference between these companies that are private companies and that are governing our public rights like free speech, and the lack of accountability or direct responsiveness or participation that users have. And instead, the only people that really feel like they have any power whatsoever are like employees, and they feel some type of like grandiose or maybe grandiose is the wrong word, but some type of need to kind of insert themselves here to kind of go against the powers that be. And it's like, it's imperfect, obviously, but I just think that it's coming from this motivation of there's just not enough there's just not enough democracy or user participation in these like foundational and fundamental power structures and private platforms that govern our basic rights.
Yeah, thank you. It is a fascinating phenomenon to see employees at these tech companies taking such public stands, often against their CEOs. Tim, I'm going to ask one more question, then we're going to go to the audience questions. Is there any role for regulation here? And if so, what is it?
That's a great question. What I think is the big story here, I really think, is more about content moderation than Section 230.
And can I stop you and ask you to explain the difference?
Yes. So content moderation, I think this is important. I think that, so content moderation is Facebook and Twitter deciding what kind of content they're going to allow on their platforms. I mean, if you haven't noticed, you very rarely see pornography on either platforms, even though obviously people post it, gets taken down almost immediately. Over the years, they have increased the number of things that they do not allow on their platforms. That is the content moderation question. Section 230 is the question of, well, what kind of liability do they have when somebody when someone puts content up that in some that violates some law, defamation, for example. So it's a different story, and I feel that content moderation is the question of our time. Indeed, sort of the most important. I said earlier, it is, to my mind, not unlike the editorial independence of newspapers. I think that's why this is a moment where we're going to test and find whether indeed the social media is independent, does have its independence the way the regular media does, or whether they react to threats. And that's why I'm actually very unhappy with what Facebook is doing. I think it is fine for Facebook to have different content moderation policies. I think that ideally, I think Kate was talking about competing rule sets. I'm a person who believes there should be a lot more competition. I have advocated the breakup of Facebook, for instance, into more social media platforms. So there's some regulation. I think there should be a lot. I just think it would be a better world with even more social media platforms with different rule sets. But what I don't think social media platforms should be doing is responding to legal threats that are unconstitutional. And that's why I think Facebook, rushing to reassure the world and the White House that they won't put labels on politicians in reaction to an unconstitutional threat is being very cowardly at this time, and is surrendering what should be their rights under the First Amendment to ignore unconstitutional threats. That's the big point here. So what is the regulation I think is important? I think antitrust law is important. I think there's also room within constitutional boundaries. Europeans are starting to do this for Congress, or for the entire for a government, for an entity with actual legislative power to, if they want to, tell the entities these are some of the guidelines we think are important. That has to be constitutionally done. But what we don't want is unconstitutional executive orders that are trying to dictate editorial policies, speech moderation policies for the entire country. That is possibly the worst outcome. So that's what I'm the most opposed to.
Thank you. We're now going to go to questions from you. You can continue to put your questions in the Q&A slot. We have many more than we can get to. Apologies for that, but I'm going to jump right in. This question is from Audrey Conklin from Fox Business. She asks for a clarification on the phrase "in good faith" in Section 230. She writes, Section 230 offers protections from liability for, quote, any action voluntarily taken in good faith, unquote. How do platforms and lawmakers decide what has been done in good faith versus what some people may feel has been done in accordance with an executive or team's political preference? Now, before you answer that, I chose this to start with, this question to start with on purpose, because we have not talked about the perception of bias. And I might mention before I ask you, the panelists, to address this question, that Axios came out with a poll asking the public what they think about political bias. And the interesting thing is, I'll just read this. 38% said social media companies are generally biased in favor of liberals. 16% said the companies are biased in favor of conservatives. So as you can see, perception is quite divided. So I did want to just bring that up in the context of this question. So Marianne, why don't I give this one to you? Do you need me to repeat the question?
No, there's a couple of interesting things there. I think on the one hand, it is important to get some of the factual statements out there, which is, for whatever the public's perception might be about bias, the evidence is clear. There is no evidence to support the claim that conservative speech is being suppressed online, or that there is clear bias against conservatives and their content. What sometimes people might mean by that is, if a platform were, for instance, to say, we're going to take down white supremacist content, and then a lot of conservatives' accounts get taken down, then maybe those accounts need to ask themselves why that might have happened. But the other important issue is that not only is there no evidence to support the idea that there's conservative suppression, it's quite clear that conservative content dominates social media. The latest figures to come out, the actual facts on this, is that they dominate social media. Twitter obviously is dominated by Trump, interstitials notwithstanding. Facebook is dominated by right-wing news. Facebook has right-wing, basically propaganda outlets, essentially doing its fact-checking. So if we want to talk about bias, that's a whole conversation we can have. It goes opposite of the way that most people are going to perceive it. But again, we're back to this notion of, look, as these private entities want, if they want to be biased, they can be. So the question, I suppose, is, do we want them to be? Do we find that to be problematic? We can talk about that. But as a First Amendment matter, they can do whatever they want. You don't have to host a racist troll in your house if you don't want to. And so if they want to kick you out, they can. So that's an important, again, First Amendment right that private entities have. Now, to the textual question about what does good faith mean in Section 230, well, who knows? And it doesn't really matter, right? This is the part of Section 230 that actually makes sense, where it says, look, if the company thinks that there's some troubling behavior on this platform, and the text of it is objectionable, which is an extremely broad term, essentially the company can do whatever it wants to take down that content. That's what it means. So the idea that you could find bad faith in that, I think, would be really difficult, because really the work is being done by that term objectionable. But if we want to look at examples of what it looks like from a free speech norms perspective, as opposed to, say, a First Amendment or Section 230 perspective about bad faith, well, it looks like an outlet that promotes certain types of political viewpoints and never allows for dissent.
Thank you. Thank you, Marianne. Tim, I'm going to direct this next question to you. This comes from Sarah Contreras. She's asking to speak about the court case of the Knight Institute. These are your colleagues. I'm adding more context here. Your Columbia University colleagues at the Knight Institute, run by Jamil Jaffer. The court case of Knight Institute versus Donald Trump, which held that the president cannot block his critics on Twitter. She's asking to speak about that and its relationship to last week's executive order.
That's interesting. So I should say that I'm pals with those people, but I don't speak for them, just in case I say something. Ridiculous.
Got it.
I don't speak for them either, but I'm going to just say really quickly, Tim, after you talk, that I just got off the phone with them 2 days ago. So I do have some idea of what they're planning outut of this, but go ahead.
Go ahead, Tim, and then I'll come to you, Kate.
Well, Kate may have a better answer. So that's why I think that their position, what we're doing here, I guess is very general, is mapping out some of the First Amendment questions surrounding social media, which really is relatively new, and a lot of the questions are unanswered. So and they all revolve around this unusual question of what is the difference between the state actors and the private actors, particularly when the private actors are big. Their position is that since Trump is a public official, when he blocks somebody, it's the same as a form of censorship in a public forum, and so that should be illegal. Now, how does that relate, to Twitter deciding it wants to do something about Trump? The revenge, the opposite. Well, Twitter is a private entity, and so enjoys, in fact, when they're blocking somebody, it's actually an exercise of their speech rights. That's what's weird about the First Amendment. Under the First Amendment, private censorship is actually a form of speech, while public blocking or public action is a form of censorship that is illegal. So that is the twist here. And maybe Kate has more to say than that.
Go ahead, Kate.
No, I think that's exactly right, Tim. Sorry, Vivian, do you?
Go ahead.
So I think that Tim's exactly right. And I think that was when I talked to some of the people at Knight. I was just kind of curious if people were looking at generally, I've just talked to a bunch of the EFF, CDT, a number of places that typically bring suit against kind of asserting these types of user rights or trying to test the limits of the platforms or the limits of government to censor the platforms. The general take just on this executive order from what I talked to is that while there is best way for it to be challenged is probably for Twitter, precisely because of the reasons Marianne said about its First Amendment rights, is for Twitter or other platforms to basically bring suit to try to say that the executive order in some way violates their First Amendment rights. And to Tim's point, that his op-ed today is about, the general consensus also was like people were not really sure whether bringing litigation around this or assisting in litigation around this didn't worsen the entire situation and give air to like this dumpster fire of an executive order. And so there is, I think that there is a solidly like a mix of questions about litigation coming out of this.
Yeah, that's right.
Thank you. This next question is from Dan Rose. He asks, with their dominant market share, aren't Twitter and Facebook natural monopolies and so could be compelled as utilities to provide service to everyone without discrimination?
That's an interesting. Can I take that one?
Go for it.
I think that's a very interesting question, and a little maybe challenging for me as a longtime advocate of net neutrality, which is the principle that the cable and phone companies, when they deliver the internet to you, they got to deliver the whole thing, and not pick and choose what you get. So I think the situation is different. I'm going to a little bit rely on what the Supreme Court has said, which is unfair. But the idea, the First Amendment line that's out there is, even if you are a powerful private company, it doesn't mean you abandon all your speech rights. Even if you're the only newspaper in town, your editorial decisions are still protected by the First Amendment. And that's largely the position that I think would protect a company like Twitter or Facebook, none of which are full monopolies, but in any case, that's the line we have. But is there some room, is there some idea that since they're so powerful, they are subject to some forms of regulation that maybe wouldn't be allowable for smaller actors? I think that's an instinct a lot of people have. And I can tell you that under current Supreme Court precedent, that regulation, if it was dictating one set of content moderation policies, would be unconstitutional. But there are people who've thought that should be a different answer for very powerful companies. Let me say one last thing about this. It is worth asking, what does the world look like if you force a sort of no holds barred approach to everything? And I think we have to deal with the reality of, while no one likes getting blocked, what we think of the online world, even as crazy as it is, collapses very quickly. The troll problem, for anyone who's run a website of any size at all, the troll problem, the pornography problems, they just become overwhelming incredibly quickly. This was sort of something people learned very quickly in the 90s. You try and have a website all about bread making or something, and then someone, turns it into either why sourdough bakers are Nazis or something like that very quickly, or just starts defaming people. So, the world doesn't work without content moderation. And that's really a fundamental difference with this and net neutrality. The internet works well if you are delivered the whole internet, all the packets coming. But online forums, social media do not work and have never, ever really existed without moderation of some kind. So that's the reality we live in.
We're quickly running out of time. This question is from Harvey Rishkoff of ABA. He's asking, this is for all panelists, and it may be by the time you all answer, that may be our last question. What specific changes we've sort of been debating Section 230 this whole time, making sure that, unpacking it, understanding it. I'm going to slightly modify, sorry, Harvey, who I know, I'm going to slightly modify your question, which is, if you could wave a magic wand or introduce legislation to make changes to Section 230, what would you change towards the world of online platforms as you would see it, as you would like it to be seen? Marianne, I'll start with you.
Sure. So there's a couple of practical things you could do. One, I think, would be to clarify that Section 230's protections only apply to speech. A huge part of the problem, although it's not directly the issue for our discussion today, but a huge problem with a lot of what happens with online content is that it in fact is not neatly falling on the side of speech versus conduct. It often is in fact conduct. And Section 230, unfortunately, allows these companies that are encouraging or profiting from this kind of content to have their immunity. So if Section 230 was clarified, if you're going to use the words like publisher and speaker and all of those things, then clarify that the immunity that you're going to get only relates to speech, and then let those companies have to fight it out whether or not whatever the issue is in fact speech or not, or whether it's unlawful activity. So I think that would actually go some ways to figure some of these problems out. The other part is to actually make Section 230 into what it claims to be, which is a Good Samaritan law. And I've written about this fairly recently, inviting people to think about, first of all, the biblical parable, right? But also what a Good Samaritan law looks like in every other context except in this one. And that is, a Good Samaritan law is not one that forces you to do anything. It doesn't impose any obligations on a person. It's a way of offering immunity to people who have no obligation and no duty of care, to actually encourage them to help other people, and in exchange for that, not to get sued for it. To actually try to make Section 230 look like that. That is, acknowledge that sometimes it does have a duty of care, especially when it's profiting from or facilitating illegal conduct. And for instances where it doesn't have that duty of care, to reward it for wanting to shape norms or to contribute to the discussion, or to take any kind of steps that it wants to actually make for a better speech environment or for a better conversation, and protect them for doing so in case they get it wrong or they overcorrect or they undercorrect. Those are the kinds of steps that I think we could take to coming at least somewhat close to what the tech industry keeps saying it's trying to do, which is to create free speech and to encourage dynamism and discourse. Because what I think really gets lost in these conversations is, when we say free speech, we should always ask, free speech for whom? Who is getting to speak loudly? Who is getting amplified? Who is actually rising to the top of the algorithms? Not just to ask or to speak in these abstractions about whether or not speech is being protected. We need a much more sophisticated conversation than that.
Thank you. I know these are complex issues, but Tim and then Kate, I'm going to ask you to answer as briefly as possible.
I think we've got a minute. So I am not excited about the use of getting rid of the selective immunities under 230 as a means of controlling the platforms. It's a kind of a weird tool. So you're basically hoping that state tort liability is going to push people in directions you want. I would just do it directly. If there's things that you want to happen and you want to have happen in the platforms, hoping that class action lawsuits, with billions of dollars of potential damages constantly on the backs of every platform out there, is going to give us a better speech environment, doesn't strike me as a great method. I do like what Marianne said about the Good Samaritan stuff, but if I would do it, I would do a little more directly. That's what Europe's investigating, their First Amendment challenges. But if we want something, we should act. And most of all, I think we need more competition, more antitrust scrutiny. We've got some of it. That's what I would rely on.
Thank you, Tim. And Kate, you'll have the last word before I...
That's dangerous. Yeah, but I think that I actually, on this issue, like, I kind of hold back because I'm very mixed about how, when you start to tweak some of these changes, what the long-term impacts are going to be on speech. I don't tend to think that the Good Samaritan solution is the best way forward, and that's primarily because I think that ultimately what we decide about who is a Good Samaritan is based exactly on kind of where Marianne left, like with what she was saying about like free speech for whom, is like kind of like Good Samaritan for whom. Like there is a lot of conflict there about how you judge a Good Samaritan and who is being censored and who feels like they're being propped up. But I do really like Marianne's point, and I think it's a smart one, and it ties into Tim. I think it ties in nicely to kind of Tim's idea about tech giants and kind of antitrust, which is in creating competition, which is that there needs to start becoming more of a distinction between platforms that are primarily about speech and platforms that are actually promoting conduct and are about providing a product that is conduct based and not speech based. Everything online is speech because it is on platforms. But at the end of the day, and there's a great case that was was shut down because of Section 230, but Carrie Goldberg brought in Grindr versus I can't remember the rest of the name of it, but Herrick versus Grindr, and was kind of trying to start making this distinction between a platform like Grindr, which is a dating app that is more about conduct than it is about speech. It's more about performing something than it is about becoming a platform for something. And I think that that's a distinction that we could start to like be making new laws and surgical rules about, so to speak. But thank you so much for having this event today, Vivian, and hosting it. And it was really fun to talk to everyone and hear what people are thinking.
Thank you. Thank you to all the panelists. Thank you to everybody that has stuck with us for your great questions. I'm sorry we couldn't get to all of them. We will be posting later today on Aspen Digital, at Aspen Digital on Twitter, the full this full session so that you can watch it later and share it with others. Thank you everybody for your time. We'll see you next time. Bye-bye.